problem?
I got a shooting range or something over there?
My property.
That's your property?
Yeah.
Okay, so people currently shooting over there now?
What's going on?
So we get a call of shots fired in the area. Listen, anytime shots fired in the area, you got your ID on you, sir?
I haven't committed a crime.
Right now there's an investigation going on, sir, for shots fired in the area. And I need to know who I made contact with. What's your name, sir?
My name's Rob. It's a pleasure to meet you, Hudson.
Okay.
Yes, sir.
All right. So we got a call of shots fired in the area. You say you own that land up there?
Yes, sir.
You live up there or just land?
Just land.
Anytime shots fired in the area, we got to come. If it's hunting, hunting time, we get a lot of calls. So we have to investigate because we don't know what's going on. So that's what I'm investigating. So again, you got your ID on you.
No, it's not illegal.
So I gotta make
I didn't break any laws.
Yeah. So we got a call of a red truck that's shots fired in the area. So do
what
you
crime?
have shots fired in the area?
That's a crime?
Yes, sir. Ran the roadway and the houses in the area.
Oh,
yes, sir.
No, it was never any.
Okay, I don't know that yet. I haven't went back. The only thing I got is a red truck.
I'm just gonna exercise my Fifth Amendment right at this point.
Okay, that's fine. I need your ID, though, sir.
I'm not gonna ID myself. I haven't broken the law.
Step out the vehicle for me, sir.
I don't consent to any searches or seizures.
I'm not searching the vehicle. Right now, you must identify yourself, sir, because I have made.
Officer Rodriguez returned to his patrol car and left the scene without further incident. That's the official summary. One sentence. No mention of the drawn firearm. No mention of the 7 minutes a man stood in his own front yard being told his hand in his own pocket was a threat. No mention of the words, "I don't even know that," spoken by an armed government agent about whether a private citizen holding a phone was dangerous. Just, he left. No further incident. Picture a man standing on a small square of concrete he owns outright. His driveway, his property line, his front door 12 feet behind him. And picture a stranger with a badge and a loaded sidearm walking onto that square uninvited, demanding the man's hands go where the stranger wants them, for a reason the stranger cannot articulate beyond one sentence. You were taking my picture. That's the entire visual anchor for this case. A man on his own land told his own hands are a threat because a camera pointed back. Before we go deeper into what the documents actually show, make sure you're subscribed to Police Misconduct Case, because we don't just cover the story, we follow the evidence.
Contacting is an ongoing investigation.
I'm exercising my Fifth Amendment right.
You're refusing to identify yourself to me.
You haven't articulated a crime.
That land belongs to you.
Yes, sir.
Do you have any backstops behind any shooting that's going on back there?
I'm not going to answer any questions.
Okay, that's fine. Give me 1 second.
Can I see your supervisor?
He is a supervisor, sir.
I allow people to hunt on that property as well. So when they're hunting, is that a crime?
How much land you got?
I'm not going to answer any questions.
I'm just going to answer.
Because I have a Fifth Amendment to the Constitution.
You want to assert your rights. I have no problem with that.
I'm being illegally detained at this point. I have no obligation to assist you in your investigation.
I just want to know what your issue is. Why you don't want to talk to us? That's
I don't
my
like
question.
police. I'm sorry. I think you guys are tyrants.
Okay. Well, technically we have enough to stop you for the incident that we're investigating. And technically, if you want to get into the aspects of the law, you're just driving down the road. We have a right to see your driver's license registration. There's Supreme Court case law on that.
Yeah, if I violated the law.
Okay.
What's the law? RAS, reasonable articulable suspicion. If you can articulate to me reasonable articulable suspicion, I will be happy to ID myself.
If you want to play the reasonable person standard, we'll play that. I don't have to have a crime to stop you. I don't have to have a crime to ID you. I don't have to have a crime to talk to you.
You have to have a crime. If I've done something wrong, I will ID myself. You tell me what I've done wrong, and I will ID myself.
Show me where in a law book anywhere that reasonable suspicion equals a crime.
Here's what the body cam actually captures, second by second. And here's why it matters more than most departments want it to. Mr. McComas is standing in front of his own house. Officer Rodriguez, patrolling in a marked unit, slows down, stops directly in front of the property, and watches. McComas does what any citizen documenting police activity in a public-facing space is constitutionally permitted to do. He lifts his phone. That single act, a man recording a police officer from his own property.
The Supreme Court recognized in the 2000 case of Illinois versus Wardlow, a detention may be justified even if an individual's conduct is lawful, ambiguous, and susceptible of an innocent explanation if it also is suggestive of potential criminal activity, and that the infamous Terry case recognized that officers can detain individuals to resolve such ambiguities, arguing that, quote, in allowing such detentions, Terry accepts the risk that officers may stop innocent people. Therefore, a report of shots fired could could serve as a basis of reasonable suspicion, even though some discharges of firearms may be legal, as shots fired could be potentially indicative of criminal activity. Nonetheless, in this situation, it is questionable whether a report that a truck was seen in an area where shots were heard would be sufficient to give the officers reasonable suspicion to pull over Mr. Huffman and detain him. In the 2011 case of U.S. versus Massenburg, the Fourth Circuit Court of
Rodriguez orders McComas to remove his hand from his pocket, repeatedly, escalating in tone each time. McComas calmly explains that his hand is empty and his property is his own.
This is where the case stops being a disagreement and becomes a constitutional violation on tape.
Is the entire trigger for everything that follows. Rodriguez exits his vehicle. Rodriguez unholsters his firearm.
held that an anonymous tip that shots had been fired in a high-crime area in which random gunfire was typical was insufficient to support a Terry stop when the tip contained no physical description of the perpetrators, and the only link between the tip and the detained group of citizens was their rough proximity to the alleged site of the gunfire. Now, on the other hand, in the 2010 case of U.S. versus Monroe, the Fourth Circuit concluded that an officer was justified in initiating a traffic stop based on the similar broadcasted description of a vehicle that was suspected as being involved in a nearby robbery that had occurred a few minutes earlier. Additionally, in the 2021 case of McCormick versus Kershaw County Sheriff's Office, the U.S. District Court for the District of South Carolina noted that although at least one other circuit had determined that the fact that a vehicle matched the general make and color description of a vehicle involved in nearby criminal activity was insufficient to establish reasonable suspicion, there was no controlling authority in the Fourth Circuit that clearly established such a rule.
Is this a Terry stop?
No, I don't think it's a Terry
There
stop.
you go.
Okay.
Am I free to leave?
You can't shoot within a certain feet of the homes. So if y'all are in violation of that, you will be charged. Okay?
There's still no crime.
Yes, it is a crime. You can't shoot within certain feet of a home, sir.
So how many feet was I in?
You're good to go, sir. Have a
All
good
right,
day.
thank you. Y'all take care. Stay safe.
After the officers allow Mr. Huffman to leave the traffic stop, they drive onto Mr. Huffman's nearby property, exit the vehicle, and approach his father, Michael Huffman, who was on the property with Mr. Huffman's permission. The exchange that followed was captured on Deputy Hudson's body camera.
How you doing? My name is Deputy Hudson with the Sussex Sheriff. Listen, sir. My name is Deputy Hudson with the Sussex Sheriff Department, sir. We got a complaint from a neighbor right here, and right here.
Get over it. We're out here. We're 200 yards from anything near us, and we're firing into the ground.
You gonna let me talk, or you gonna finish?
I'm gonna finish. You are trespassing. You are not allowed on this property. The gate was closed.
Sir, you got your ID on you?
I don't have to give you ID. The Constitution says I don't have to give you an ID unless I have broken a law.
Do y'all own this residence right here, sir?
Yes.
Who owns it?
My son and I own it.
Okay, what's your name?
Again.
I don't know if you trespass or not. What's your name, sir?
My name is.
Your son's on it.
Our family own it.
Okay, so did he give you permission to come out here? Did he give you permission to be out here?
Yes, he has. But I have permission. You don't get to my property.
So he gave you permission to be out here, sir?
Yes. Did you or did you not pull him over? Not 5 minutes ago.
No, he didn't identify himself. I don't know who he is. Did he give you permission to be out here, sir?
I have permission to be on my own property.
Can you call and verify that he gave you permission?
And I've been telling him the same thing.
So who's the owner of the property?
He is.
What's his name?
Off my property.
What's his name, sir?
Get the off my property.
You have your ID on you, sir? So we're trying to figure out who property this belongs, because it looks like some abandoned property. Do you have your ID on you, sir?
I don't need an ID.
Sir, I can't leave right now because of the open investigation.
You're trespassing.
Sir, you might want to calm down before you go to jail, sir. You might want to calm down. Well, if he owns it, he needs to come back and show his ID. Okay, that's fine.
Get the hell off my property.
Sir, turn around, put your hands behind your back. Turn around, put your hands behind your back for destruction and not cooperating with law.
Because the standard here isn't complicated. It's not new law. It's not some gray area waiting on a future Supreme Court ruling. The right to film police performing their official duties in a place the public can see them has already been settled by circuit court after circuit court. In 2011, the First Circuit ruled in Glik v. Cunniffe that filming government officials engaged in their duties fits squarely within First Amendment protections. because gathering information about public officials and making that information available to others served what the court called a core First Amendment purpose.
Failing to identify does not violate Virginia's obstruction statute, which is found in Section 18.2-460 of the Virginia Code. Although the statute states that, quote, if any person without just cause knowingly obstructs any law enforcement officer in the performance of his duties, he is guilty of a Class 1 misdemeanor, Virginia courts have construed the term obstructs more narrowly than some other states have. As the Court of Appeals of Virginia explained in the 1998 case of Ruckman versus Commonwealth, quote, to constitute an obstruction of an officer in the performance of his duty, it is not necessary that there be an actual or technical assault upon the officer, but there must be acts clearly indicating an intention on the part of the accused to prevent the officer from performing his duty. As to obstruct ordinarily implies opposition or resistance by direct action. It means to obstruct the officer himself, not merely to oppose or impede the process with which the officer is armed. Further, the court also noted that, now quoting again, there is a broad distinction between avoidance and resistance or opposition, and that, quote, obstruction of justice does not occur when a person fails to cooperate fully with an officer, or when the person's conduct merely renders the officer's task more difficult, but does not impede or prevent the officer from performing that task.
Here's the ticking clock question the file forces you to ask. If an officer can draw a firearm on a citizen for the sole act of recording him, how many cameras across this country have already been lowered out of fear before this case was ever filed? McComas presses him directly. Am I being detained? Are you accusing me of a crime? Are you suspecting me of a crime? And Rodriguez's answer is almost an admission on its own. If I did, I would arrest you, so go ahead and have a nice day. Translation? I have nothing. No charge, no suspicion, no crime. I have a man with a phone, and I don't like it. That's the entire basis for a firearm being pointed at a private citizen standing in his own front yard. The badge doesn't outrank the Constitution. And it's not isolated to one circuit. The Ninth Circuit, the circuit with direct jurisdiction over California, the circuit that governs this exact case, reached the same conclusion in 1995 in Fordyce v. City of Seattle, recognizing a First Amendment right to film matters of public interest.
In part on this precedent, the Attorney General of Virginia concluded in Official Opinion 02.082 issued on October 10, 2002 that, quote, a law enforcement officer, even when armed with reasonable suspicion that criminal activity may be occurring, may not arrest a suspect for obstruction of justice on the basis that the suspect refuses to identify himself. Therefore, it is highly likely that a court would conclude that Mr. Huffman could not be legally arrested for refusing to identify himself or, quote-unquote, cooperate with the officer's investigation.
This is my question, Mr. Huffman. Are you ready to talk yet?
About what?
The property. This is the thing.
Like I said, my son's wife was raised in that trailer
and
right there all of her life. So I tried to explain it to anyone.
Did you give me your ID? We had to basically go through this whole process. So check this out. Somebody comes out here and shoot on your property, right? I come out here, I say, hey, why are you shooting out here? This is my property. I let them go. You call the police and say, hey, somebody was shooting out there. Guess what? I don't have their ID.
That's not activist language. That's a federal appellate court describing the exact behavior McComas engaged in, word for word. That precedent has only expanded in the decades since. So by the time Rodriguez stepped out of his cruiser with his hand on his weapon, the law wasn't ambiguous. It was decided. Twice, in two separate circuits, 3 decades apart, saying the same thing. A camera pointed at a police officer in public is not probable cause. It's not reasonable suspicion. It's not justification to draw a firearm on an unarmed man standing on his own property. Say that phrase with me, because it's going to come back. The badge doesn't outrank the Constitution. Now watch what happens next, because this is where the forensic gap between what was said and what was true opens all the way up. Rodriguez tells McComas to take his picture and leave.
My son's wife was raised in that trailer right there all of her life.
So
I tried to explain it to anyone.
Did you give me your ID? We had to basically go through this whole process. So check this out. Somebody comes out here and shoot on your property, right? I come out here, I say, hey, why are you shooting out here? This is my property. I let them go. You call the police and say, hey, somebody was shooting out there. Guess what? I don't have their ID. I don't have the information, so now I'm not able to identify that it was on your property.
Whatever happened to you're not trespassing on the property.
We got a call and we have to follow through. So that gives us our suit to arrive on the property.
So you can cross gates and you can go...
Yes, sir, and investigation. Yes, sir.
I did not know that.
Deputy Hudson claims that the officers were permitted to open the gate to enter Mr. Huffman's property because they were in the 1984 case of Oliver versus United States. The Supreme Court concluded that narcotics agents did not violate the Fourth Amendment or even conduct a Fourth Amendment search when they walked around a locked gate with a no trespassing sign to enter a quote-unquote open field, arguing that, now quoting, because fences or no trespassing signs do not effectively bar the public from viewing open fields, the asserted expectation of privacy in open fields is not one that society recognizes as reasonable. The court also determined that whether or not the officer's actions would be considered trespassing was not dispositive in the analysis because, now quoting, the law of trespass forbids intrusions upon land that the Fourth Amendment would not prescribe. For trespass law extends to instances where the exercise of the right to exclude vindicates no legitimate privacy interest. On the other hand, as the Supreme Court explained in the 1987 case of United States versus Dunn, the Fourth Amendment does protect so-called curtilage, which is the area immediately surrounding the home. In the Dunn case, the court identified 4 factors that courts should use to decide whether property is part of the curtilage of a home or an open field. Now quoting, the proximity of the area to the home, whether the area is within an enclosure surrounding the home, the nature and uses to which the area is put, and the steps taken by the resident to protect the area from observation by passers-by. In this situation,
McComas responds that he doesn't have to leave. He's on his own property. Rodriguez says, neither do I. Except that's not accurate, and it's not close to accurate. Rodriguez has no lawful basis to remain on that property issuing commands unless he has reasonable suspicion that a crime has occurred or is occurring. He doesn't. He never articulates one. The only justification offered on tape, in his own words, is that McComas was taking his picture, and he was taking McComas's picture back. That's not a legal standard. That's a personal grievance dressed up as law enforcement.
What happened after the encounter is where the paper trail becomes impossible to spin.
As the Supreme Court explained in the 2013 case of Florida versus Jardines, quote, the knocker on the front door is treated as an invitation or license to attempt an entry. And, now quoting again, this implicit license typically permits the visitor to approach the home by the front path, knock promptly, wait briefly to be received, and then, absent invitation to linger longer, leave. Thus, a police officer not armed with a warrant may approach a home and knock, precisely because that is no more than any private citizen might do. Although
McComas didn't just post the footage, he filed a federal civil rights lawsuit alleging that Rodriguez violated his First Amendment rights to free speech and assembly through an unlawful detention carried out at gunpoint over the simple act of recording. This is not a complaint sitting in a drawer. This is a federal case built on video evidence, built on settled circuit precedent, and it produced a result that departments rarely want made public. Officer Rodriguez was denied qualified immunity. For those unfamiliar with what that phrase actually means in practice, qualified immunity is the legal shield that protects officers from personal liability unless their conduct violates a clearly established constitutional right. Judges do not strip that shield casually. When a court denies qualified immunity, it is telling the officer, in effect, the law here was clear, you should have known it, and you don't get to hide behind your badge for this one.
U.S. District Court for the Western District of Virginia noted in the 2013 case of U.S. versus Jones, quote, the Fourth Circuit has made it exceedingly difficult for a homeowner to withdraw the implicit consent which underpins the knock and talk rule. In support of this contention, the court cited the 2004 case of Edens versus Kennedy, where the Fourth Circuit held that, quote, if the owner of a home encloses the curtilage with a fence, locks the gate, and posts no trespassing signs, the effect for Fourth Amendment purposes is to extend the walls of the home to the edge of the curtilage. Therefore, unless the gate was locked and no trespassing signs were posted, it seems likely that a court would conclude that the officers did not violate the Fourth Amendment by opening the gate to enter the property and speak with Mr. Huffman.
You're trespassing. I want you off my property.
You the owner of this property?
I'm not answering any questions.
Okay, sir. Well, I don't know if you're the owner of the property. Please step back away from me, sir.
Trespassing.
Are you the owner of this property?
You're the only one.
Are you the owner of this property,
I'm
sir?
not answering any of your questions.
Okay, that's fine.
Oh, so you're going to arrest my father?
Do you have your ID on you, sir?
I'm not answering any
Okay, well, I'm going to ask you to leave, sir, if you're not the owner of this property.
Okay, I'm the owner of the property.
Okay, then do you have your ID so I can identify that you're the owner of the property?
No. How's you going to kick me off my property?
Because you're not identifying yourself that you're the owner of this property. That's fine, sir. So I'm asking you to get in your truck and leave, sir.
No, I'm asking you to leave.
Are you the owner of the property? So at this time, sir, if you're not willing to identify yourself, I'm going to ask you to leave, sir. Okay, turn around, put your hands behind your back, sir. Thank you.
I want to see your supervisor.
Right now, you're being detained, sir, so we can identify you, sir. No, I'm not.
Trespassing?
No, sir. Why we got him?
Are you?
Do you have any weapons on you?
Yes, I do. I have a 9mm Glock on my right side.
Okay. I'm going to
Why
is
don't
it one
you
in the
not
head?
muzzle flash?
Is it one in the head?
Come here and videotape these guys.
Stand right here, sir, and stop.
Lean against the car for me, please.
Stand right here, sir.
Stand right there and relax, okay?
Don't muzzle flash.
Stand right here, sir.
You don't know how to use
Stand right here, sir, and calm down.
Please.
Calm down.
Please.
You're moving back, sir. You're not being compliant.
I'm complying. You fucking pointed that gun at me.
Sir, stop cursing at me before you receive a charge.
I have the freedom of speech.
No, you don't.
I don't have the freedom of speech on my property. Video record this, Alec, Jared.
You got anything on you that's gonna poke me, stick me, or hurt me, sir?
Yeah, I got these nuts in your mouth. You pointed a gun at me, you dumb.
What's your name?
These nuts in your mouth, fat boy. Y'all's, I'm gonna get y'all's fucking cameras too. Is that thing on?
Is it your property?
Yes.
You got anything to prove it is your property?
My wife sent me the deed on my phone that you confiscated without a warrant.
No, I don't.
Oh, you think it's funny? You see, you guys are lowlifes, man, and you're proud of yourself. Didn't you swear an oath to the Constitution?
All right, so you have a right to remain silent. Anything you say will it can be used against you.
So, Mr. Huffman, if we could just establish that the property is yours, and if you can do that easily by showing us the deed on your phone, that would greatly help our situation out.
So do you have that?
Yeah, I have it on your phone. The one that you took from me, Hudson.
Investigative detention, and we'll do what we have to do, okay? All we're looking for is a little compliance. That's all,
you don't
please,
get
sir.
any compliance.
Do you have the deed and
I'll
you
show
wouldn't
you
show us
the
the
deed, Hudson, you low-life piece of shit.
This time, sir, you're gonna be charged.
You're gonna charge me with trespassing on my own property?
No, I'm charging you for your verbal abuse.
Oh,
and your
that's the
profane
First
language
Amendment
use.
to the Constitution.
No.
I'm on my property. The first, are you aware? Are you familiar
Sir,
with
let's
the First Amendment?
listen, sir. Let's cut
You
it
don't know
short.
the
With
First
nothing else to say,
Amendment?
sir. Turn around right here,
That's
sir,
the
and just
first-
wait till a supervisor
That's
get
the
here.
First Amendment. It's freedom of speech.
Sir,
I can say anything I want.
You're right.
You
you're
just
right.
said you're arresting me
You're right, sir.
for using foul language.
You're right, sir.
When Mr. Huffman directs a profanity at Deputy Hudson,
The case was set for trial. That's the part departments hope gets buried in a settlement summary. This wasn't dismissed. This wasn't thrown out on a technicality. A federal judge looked at the video, looked at the law, and decided a jury needed to hear it. And then before that jury ever got the chance, a settlement was reached, and Officer Rodriguez retired from the department while the litigation was still active. The amount of that settlement was never made public. No press release, no line item in a city budget report anyone can point to. A man draws his weapon over a photograph. A federal court says the case survives trial, and the final number that changed hands stays sealed from the public that funds the department. The badge doesn't outrank the Constitution.
2-416 of the Virginia Code states that, quote, if any person shall, in the presence or hearing of another, curse or abuse such other person, or use any violent abusive language to such person concerning himself or any of his relations, or otherwise use such language under circumstances reasonably calculated to provoke a breach of the peace, he shall be guilty of a Class 3 misdemeanor. However, in the 1973 case of Mercer versus Winston, in order to ensure that prosecutions under this statute did not violate the U.S. Constitution, the Supreme Court of Virginia limited its application to so-called fighting words, or, now quoting, words that have a direct tendency to cause acts of violence by the person to whom individually the remark is addressed. As this category, Circuit Court of Appeals concluded in the 2021 case of U.S. versus Bartow that an individual could not be convicted of violating this statute for using a racial slur when the government did not prove that the individuals to which the slur was directed actually responded violently, or that a reasonable person in their positions would have done so, despite acknowledging that, quote, the ugly racial epithet used undoubtedly constituted extremely abusive language. Additionally, it is important to note that Mr. Huffman's allegedly abusive language was directed at a law enforcement officer. And as we have discussed before here on ATA, the Supreme Court explained in the 1987 case of Houston versus Hill that, quote, the First Amendment protects a significant amount of verbal criticism and challenge directed at police officers, and that it is, now quoting again, again, protected against censorship or punishment, unless shown likely to produce a clear and present danger of a serious substantive evil that rises far above public inconvenience, annoyance, or unrest. In the Hill case, the court also favorably cited Justice Powell's concurring opinion in the 1974 case of Lewis versus City of New Orleans, where he, now quoting, suggested that even the fighting words exception might require a narrower application in cases involving words addressed to a police officer, because a properly trained officer may reasonably be expected to exercise a higher degree of restraint than the average citizen, and thus be less likely to respond belligerently to fighting words. Applying these principles, the Court of Appeals of Virginia held in the 2000 case of Martilla versus City of Lynchburg that an individual could not be convicted for using abusive language against police officers when he directed derogatory and profanity-ridden insults at them, concluding that the evidence was insufficient to prove that these statements, now quoting, had a direct tendency to provoke an immediate breach of the peace by reasonably trained police officers in the position of the officers to whom the remarks were addressed. In support of its decision, the court argued that, quote, this is precisely the type of verbal criticism of police officers that is protected against censorship or punishment by the First Amendment, because it is not, under the circumstances established by the record, likely to produce a clear and present danger of a serious substantive evil that rises far above public inconvenience, annoyance, or unrest. Accordingly, it is highly probable that a court would conclude that Mr. Huffman could not be convicted of a violation of abusive language for his speech, as a well-trained police officer would not be incited to violence by his use of profanity or his insults, and Deputy Hudson did not appear to be actually physically provoked by his language.
Robbie, shut up. He's just jumping at straws to have some way to be a big man.
Yes, sir. Okay. Where's the name at? All right, we're going to finish this up. Where's the name at? All right, we're going to finish this up and they'll be on their way. She showed us the deed. Get this paperwork. No, I'm not I'm got to,
You're going to violate his right
stroke this stuff. Cool. I'm charging him, though.
Okay.
Why are you charging him?
All right, so this is what we can do, sir. I can stroke you a summons and let you go, or you continue to talk. I can take you to the jail and take you in front of the magistrate.
I just want to know, I want you to write on that sentence what law I have broke. Because I have not broken any law.
After determining that Mr. Huffman was the lawful owner of the property, Deputy Hudson issued citations to both Huffmans for using abusive language in violation of Section 18.2-416 of the Virginia Code. As of the date of writing this episode, both charges are still pending. It is unclear whether the Huffmans have filed a complaint or intend to pursue legal action for any violations that occurred during this encounter.
2015.
On July, California resident Don McComas was standing in his driveway, attempting to attach his boat trailer to his truck when he noticed Officer Dave Rodriguez of the Rohnert Park Police Department slowly creeping down the street in his police cruiser. Mr. McComas found the officer's behavior suspicious, so he pulled out his phone and began recording from his driveway.
He's now circled the neighborhood, now he's headed back towards me. He's been very slow in all of his driving. Clearly didn't like that I was pointing my camera to videotape him, but he came around the area very slow. He's on and off his microphone right now. He's now calling in my license plate number of my excursion. He thinks he's being funny now.
Go take your hand out of your pocket, okay?
No, sir, I haven't done nothing. I've done absolutely nothing, no.
Hey,
Seriously.
Put your gun down, really?
That's the moral refrain of this entire case. Said 3 times because it needs to be said 3 times. Once when the gun came out, once when the qualified immunity shield fell away, and once now, at the end, when the settlement number disappears into a sealed file while the officer walks into retirement with his pension intact. The system is designed, in cases like this, to let the actual cost disappear from view. The behavior gets buried in a settlement clause. The officer gets a clean exit. The public gets a 2-line summary that says the parties reached an agreement and the matter is resolved.
In the 2018 Third Circuit case of United States v. DeCastro, the court concluded that a simple request to remove hands from pockets without additional coercive conduct does not require reasonable suspicion, and that officers are free to ask citizens to remove their hands from their pockets without invoking the citizen's constitutional protections. However, the court emphasized that if an officer orders a citizen to remove their hands from their pockets, then they must first have obtained reasonable suspicion. The key distinction in determining whether an officer has the authority to order a citizen to remove their hands from their pocket is whether or not the officer had reasonable suspicion to detain the citizen at the time of the order. As noted in the DeCastro case, along with many others, quote, police conduct rises to the level of a so-called seizure when, by means of physical force or a show of authority, a person's freedom of movement is restrained. As noted in the DeCastro case, along with many others, quote, police conduct rises to the level of a so-called seizure when, by means of physical force or a show of authority, a person's freedom of movement is restrained. Now, in this interaction, it could be argued that Officer Rodriguez's act of unholstering his firearm served as a quote-unquote show of authority that could have transformed this stop from a consensual encounter into an investigative detention. This would require that Officer Rodriguez meet the standard of reasonable suspicion before ordering Mr. McComas to remove his hands from his pocket, or else the interaction could violate Mr. McComas's constitutional rights by restricting his movement without legal justification. Now, we will discuss whether Officer Rodriguez actually had reasonable suspicion in a moment, but for now, it is important to understand that reasonable suspicion is required for officers to issue orders that restrict a citizen's movement, and it is arguable that if Officer Rodriguez did not have reasonable suspicion when he issued his orders, then he may have illegally detained Mr. McComas by unholstering his firearm to gain Mr. McComas's compliance.
This one's really got a gun on me. No. You don't touch me. You don't touch me.
I'm at that address.
You don't touch me.
Hey, man.
No, you don't touch me.
When I tell you to take your hand out...
I've done nothing.
Okay.
Nope.
You need to relax.
You go away.
Okay. I don't go away. I stay where I am. You can go in your house if you want, or you can stay out here. But you don't keep your hand in your pocket. Okay?
My hand can be in my pocket. There's nothing in there. I've done nothing. What have I done?
I'm telling you.
Answer me. What have I done? Why'd you get out of your vehicle?
You're taking a picture of me. I'm taking a picture of you.
Officer Rodriguez explains that the reason he exited his
Here's the part worth sitting with. Nothing about what McComas did that day required special legal knowledge. He didn't do anything except stand on his own property with a phone in his hand. Every protection that ended up mattering in that federal courtroom already existed before Rodriguez ever pulled up to that house, decided by the First Circuit in 2011, reinforced by the Ninth Circuit years earlier. Sitting in the case law the moment Rodriguez chose to draw his weapon instead of simply driving on. The officer wasn't caught by some obscure new interpretation of the Constitution. He was caught by law that had already been settled for years in his own jurisdiction, and he chose to test it anyway, on a man standing in his own yard.
Police under the First Amendment. This is likely due to the court considering the matter as having been resolved by the circuit courts. In the 2011 First Circuit case of Glik versus Cunniffe, the court held that, quote, the filming of government officials engaged in their duties in a public place, including police officers performing their responsibilities, fits comfortably within these principles. Gathering information about government officials in a form that can readily be disseminated to others serves a cardinal First Amendment interest in protecting and promoting the free discussion of governmental affairs. Several other circuit courts have reached the same or similar conclusions over the years, including the Ninth Circuit Court, which has jurisdiction over California. In the 1995 case of Fordyce versus City of Seattle, the Ninth Circuit noted that citizens have a, now quoting, First Amendment right to film matters of public interest, and implied that video recording public officials is...
This case sits in the federal court record as a completed civil rights action, a filed complaint, a ruling denying qualified immunity,
and a docket showing the matter resolved by settlement before trial. Public court filings in cases like this typically include the original complaint, the judge's order on the immunity motion, and any settlement approval on record with the court. If you want to see exactly how a federal judge reasoned through the qualified immunity denial in this case, that order is part of the public court docket, and it lays out, in the judge's own language, exactly why Rodriguez's conduct fell outside the law's protection. The unanswered question the file leaves behind, the one departments never seem to answer in any press release, when qualified immunity is denied and an officer quietly retires before trial, and the settlement is sealed, who actually reviews whether that officer's conduct pattern gets flagged before the next department hires him?
Leave your answer in the comments. Tell us what you think happens to an officer's record after a case like this settles quietly. If this kind of forensic breakdown matters to you, if you think the public deserves the full paper trail, not the 2-line summary, hit like, share this with someone who needs to see it, subscribe to Police Misconduct Case, and turn on notifications so you don't miss the next case we take apart, document by document.
Leave.
Okay, I don't have to leave.
Neither do I.
So, I told you to take your hand out of your pocket. I just want to make sure you don't have a weapon.
You know I don't have a weapon on me.
Okay, I don't know that.
You do that. I'm completely
Gun
clear.
out.
Wrong. Okay. You have your gun out because you're a police officer. You're trying to intimidate me, and this is going all over YouTube.
Put it on.
This is horrible. Trust me, I will.
Okay.
You guys have done enough to my family.
Okay. I don't even know who you are.
That's why you just happen to slowly approach my house, stop in front of my house,
I don't even know
and then keep going. So that was just random. That was just random?
Yep.
So you stopped. You didn't stop at anyone's house.
You, man?
You didn't stop at anybody's house but mine.
What's wrong with you?
Your station is corrupt.
Oh, okay. Are you some kind of a constitutionalist?
No, sir.
Crazy guy or something like that?
Is that what you're going after? Is that where you're going?
Are
you throwing claims around?
I'm asking you.
Are you throwing these around?
What's that?
Are you throwing labels around?
Why are you doing this?
Why are you sitting here with your gun out at me? This is why I'm doing this, to protect myself from you.
Okay. All right. Well, you just stay right in front of me, and then we'll be all fine. Okay?
Am I being detained? Have I been accused? Are you accusing me of a crime? Are you suspecting me of a crime?
If I did, I would arrest you. Okay? So, go ahead and have a nice day. Put it on YouTube. I don't really care.
I will, sir.
Okay?
Getting my stuff from my car.